Hi there, this is Samantha from the Law Offices of Samantha Wolfe, and I'm taping this in my office at 20 East 6th Street, Suite 206 in Waynesboro, PA. You can reach us at 717-655-2676. And I wanted to do a presentation discussing asset protection and long-term care planning, and specifically the use of trusts and how they work. I've been talking with some financial advisors and some accountants in the community, and there's a lot of questions, I think, about how trust can be used to provide asset protection. So I wanted to do a presentation discussing that. And what I will tell you is immediately after I go through the slides, I'm also then going to be taping two hypotheticals where I give actual facts with some numbers and show different ways that trust can be used to offer some protection. So what I'm going to then send on to different advisors and CPAs, accountants, those people who refer to us, would be the actual presentation, the PowerPoint presentation, and then I will also send the hypotheticals with a corresponding visual that shows what our recommendations at our office would be. And this can just be used as an example of why we recommend certain things, or just so you can see how the trusts work with an estate plan. So that being said, let me switch over to my PowerPoint presentation. Okay, so the title of this presentation is What's in Your Closet? Creating an Asset Protection Plan. The reason why I chose this title was because I have really developed an affinity for a great closet in my house. When I was looking at buying my first house, I took my parents along. My dad has a lot of building experience, and I took him along with me. And of course, my mom was there as moral support. But, when we went in to view each house, my dad would go and look at the foundation and look at all the different equipment and different parts of the house to make sure it was a solid buy. But my mom and I, one of the things we did, actually the first thing we did, was rush in to see what type of closet. And the reason is because I do have a lot of shoes and clothes, and so a closet is really important to me. But it also got me thinking that, growing up, I had a great aunt who lived in an old farmhouse, and she always stored her most treasured possessions in a closet. And when we were little girls, my sisters and I would go over there and want to dig through her closet and find out what treasures she had buried in the back there. So whenever I'm talking to clients, one of the ways that I try to explain trust is that a trust is really just like a closet. So you can create it any way you want it, you can build it any way you want it, and then you can transfer assets into that closet. And when you transfer assets into that closet, those assets are then bound by the rules of the closet or the trust, if you will. So, who has the right to go into the closet and pull assets out? Can they rearrange the assets? Who has the right to open the door? Those are all different ways that when I'm trying to explain that to a client, it's really helpful for them to kind of have a visual. So as I go through this, I'm going to relate it to a closet just because I do think that that is a great visual for everyone to have in the back of their mind as to what a trust is. So if we think of a trust as a lot like a closet, then it allows us to help explain it better. So that's how I'm going to be explaining it. And as I said, we're located at 20 East 6th Street in Suite 206 in Waynesboro, and you can reach us at 717-655-2676. So who needs asset protection? So in our office, when we're meeting with clients, a lot of times they'll ask, well, who do I need it? Who needs it? And so what I tell clients is that it can be physicians, CPAs, attorneys, financial advisors, insurance agents, business owners, property owners. Those are kind of, I would say most people think of those areas, those professions, as people who may be a little bit more high risk. And so they assume that those are the only people who needs asset protection. But what I like to tell people is that if you are aging and planning for the second half of life, one of the biggest creditors that could potentially be in your future is a nursing home. And how do we protect assets when we're dealing with a potential nursing home? So I would say an ideal client that would come into our office would actually be very similar to my parents. They would be, early 60s, maybe even in their 50s. We get, I would say, the bulk of our clients that we meet are between the ages of 50 and 75. It's not to say we don't have some that are older. That's not to say we don't have some that are younger, but I would say that's really the age group that tends to meet with us in our office. And anybody who is in that age group should at least consider asset protection. And the reason is that if we're taking the example of my parents, my dad's name is Denny and my mom's name is Denise. Um, it's a lot of fun, I know. So let's just say that something happens to my dad and he needs to go into a facility. The reality is that there are going to be certain assets that are going to be exempt, meaning that a nursing home cannot take those assets in order to pay for my dad's care. But after you remove those assets, then my mom is only left with her retirement, because her retirement is going to be protected against my dad's care, a vehicle of highest value. The primary residence would be protected. So those are all those exempt assets you can take out right away. But everything else is going to be subject to my dad's care. And that's whether my mom's name is on the title or not. So she then has what we call a protected share. So the spouse who's still in the community can keep about $128,000, and the spouse who's in the facility, it depends on what their income is. So they can keep anywhere from $2,400 up to $8,000, just depending on what their monthly income is. It kind of changes what their asset totals can be. But my mom would only be allowed to keep about $128,000. So what we do at our office is we talk about, can we do something to help someone in my mom's situation to protect assets? Because if something would happen to my dad, my mom could live another 20 years. And if everything goes to pay for my dad's care, it could potentially leave her financially compromised. So really what we're doing is we're talking about what can we as advisors, whether that be the attorney, the financial advisor, the accountant, what can we do to help give our clients peace of mind? From a business standpoint, it's also helpful for financial advisors as well, because using these type of asset protection strategies also ensures that your asset base won't be diminished by the cost of long-term care. So while we all want to put our clients first, there also is a business angle of this too, which is just making sure that the asset base for your clients is not being diminished by the cost of long-term care. So even though I meet with clients and they usually come in unaware that asset protection is something they should be considering, I always want to have that discussion. So what are we getting the protection from? So there's two ways that we can get protection. So in the example I said with my mom and dad, that deals with long-term care, nursing home protection. But there's also other types of protection that these trusts can offer. So it can protect against divorce. It can protect against death, debt, disability, meaning a nursing home. And so when I'm talking about the two types of protection, the first is protecting yourself. So my mom and dad protecting assets for each other. That's one protection. But then it also goes to the next generation. So protecting assets for those future generations. And our goal is that we want to put an estate plan in place that protects our client and also those future generations. So we're asking, what are we protecting from? We actually want to protect you, the client, the beneficiary, or both. And so as trusted advisors of the clients, whether it be accountants or financial advisors, what we're able to do using these trusts is offer protection for clients, for the beneficiary when mom and dad or the client pass away. We're able to offer protection in both situations using these type of trusts. So how do we protect assets? So just like I talked about two types of protection, while the client's living, and then when the client passes away, there are also two main ways that we can protect assets. So the first way is that there might be an investment product. So sometimes we'll work with financial advisors who are doing long-term care insurance, whether it be a traditional insurance product, long-term care insurance, or it might be a life insurance product that has a long-term care rider, or some other investment product that the financial advisor is bringing on board. And that's why we really strive in our practice to include the financial advisor and the accountant as part of the team. It's one of our core principles in our mission statement is collaborating with those trusted advisors, with financial advisors, with the accountants. Because really the best way that we can offer an asset protection plan is to get all of those different advisors together so that we can provide the best plan. So like I said, the first way is the investment product. The second way is an irrevocable trust. Now, I don't mean that these have to be separate and only used, for example, it's not that you only use the insurance products or you only use the trust. They can actually be used very effectively together. And I've seen this used a lot because there's a 5-year look back period, which I'm going to discuss with the irrevocable trust. So the long-term care, even if it's just traditional or it could be a hybrid product, either way you use it, that insurance product could be very helpful to make sure we make it through that 5-year look back period. And in Pennsylvania, it's an all or nothing. So if you're in year 3 of your look back period, meaning you had 5 years, you tried to transfer assets into a trust to get the protection, and in year 3, somebody needs long-term care at the skilled level, then everything in that trust is available. Now you can try to privately pay through the remaining 2 years to make it through the 5 years, so those trust assets are protected, but it's an all or nothing. If you don't make it through the 5 years, those assets are still protected. Or still are not protected, I should say. So that's why it's not an all or nothing. So I always want to bring financial advisors on board to have that discussion about long-term care insurance products and how they can work, just as I would like to offer the trust as, a solution as well for advisors to be able to use these trusts in conjunction with those long-term care products. I think that makes a great overall plan if we're actually able to use them in conjunction with each other. So I would say that, people always say, well, what are the disadvantages of using these trusts? Because I'm going to talk a lot about what advantages they have. And I would say the biggest disadvantage of using the irrevocable trust is that it does trigger a 5-year look back period. And the 5-year look back period is based on the fact that every year there is a divisor, a penalty divisor that they release that says for every so much, it's 1 month Medicaid won't cover. So in 2020, that's $10,732. So if my parents transfer that $10,732, that's 1 month that Medicaid won't cover. So when we use these trusts and we're trying to figure out how long the look back period is, we take the amount that you transfer into the trust and we divide that by the 10,732, knowing that the longest the look back period can be is 5 years. So that's how you determine the look back period. And when we're talking about the 5-year period, not everybody has a 5-year look back period, because if they didn't transfer assets in the amount that would equal a 5-year look back period, then it may actually be a shorter look back period. So what is an asset protection plan? So again, our goal is we want to work with those trusted advisors to actually come up with an asset protection plan. And that is a plan designed to help clients protect wealth and assets from creditors related to the action of others. So again, sometimes we have businesses, sometimes we have vehicle and accidents, those type of things. The plan is designed to protect a client from all of those different creditors, whether it's something they did or something else that someone did, the actions of others that's jeopardizing their assets. It's also about positioning a client in the best tax structure to minimize taxes. So I know that a lot of times I get a question about the tax implications of using these trusts as part of an asset protection plan. And please know that these trusts are not going to change anything about the tax structure. And by anything, I mean income tax wise or Pennsylvania inheritance tax wise. So for example, if my parents set up this irrevocable trust and they transfer assets into it, let's just say their primary residence, and they sell their primary residence while they're living, they are still going to get the 121 exclusion. That's the federal income tax exclusion that says because they sold their primary residence, as long as they've lived there 2 out of the last 5 years, they're able to shelter for a married couple $500,000 worth of capital gains. So even when we transfer the home into the trust, they're still going to get that exemption or that exclusion. They're also, when my parents pass away, it still is going to be subject to Pennsylvania inheritance tax, because these trusts are designed to allow the client to have control and to still be in charge of those assets and to provide some protection. So for that reason, it's still included in their estate for Pennsylvania inheritance tax purposes. But the important part about that is that means there's a stepped up basis. So whether you put stock or real estate in there, when husband and wife, when the second one passes away, there will be a stepped up basis on the assets owned inside the trust. So again, it's still subject to inheritance tax, and the inheritance tax is based on whatever rate the beneficiaries are at. So again, if it's children, it's 4.5. If the trust beneficiaries are siblings, it's 12%, and anyone else that's a trust beneficiary is going to be taxed at 15%. So if the house, on the day my mom, if she's the second one to die, if the house fair market value is $350,000, those beneficiaries do get the stepped up basis to $350,000. Additionally, as a result of that stepped up basis, really, they're going to have to pay Pennsylvania inheritance tax at 4.5%, or we would, as the children, 4.5% of that $350,000. So we still get the stepped up basis, but the assets in the trust are still subject to inheritance tax. Now, if we're talking about my parents' case, as they age, what we can do with a trust is we can allow them to relinquish certain powers that they're retaining in the trust. These type of trusts are set up so that in the case with my parents, it's Denny and Denise, and then they have 4 daughters. So I'm one of 4 girls. I'm actually the third of 4. And so let's say my parents say, well, we want everything to go to the 4 of them equally when mom and dad die. So what they're going to do in the trust is they're going to retain the power to add and remove beneficiaries. So even though when we're talking about this type of trust, an irrevocable trust, mom and dad are still going to retain the power to change the beneficiaries, to add and remove them. So it's very different from an irrevocable trust that you might Google or look up online or do research on. It's an irrevocable trust where the grantor, in this case, Denny and Denise, my parents, are going to retain the power to add and remove beneficiaries. Because they retain that power, it is an incomplete gift for federal gift tax purposes. So no 709, no federal gift tax return needs to be filed. It is still subject to Pennsylvania inheritance tax when they die, and there will be a stepped up basis on the assets inside the trust, all because they retain the power to add and remove those beneficiaries at whatever time. Now, if as my parents age, they make the decision, let's say, they're in their 90s and they make the decision that they want to go ahead and transfer that on to my sisters and I. If they relinquish their right to add and remove the beneficiary, so if they come to me and they say, can you do a relinquishment, which just means I'm writing up a legal document that says Denny and Denise no longer have the power to add and remove the beneficiaries to this trust, and they sign it and they survive that by 1 year, then the assets inside the trust are not subject to Pennsylvania inheritance tax because it was transitioned during their life. The downside of that is that we, as the trust beneficiaries, get carryover basis in the assets. So we avoid the inheritance tax at 4.5%, but we do not receive a stepped up basis. So that's only though if Denny and Denise, if my parents, give up the right to change the beneficiaries. If they maintain the right to change the beneficiaries all the way up until when they die, then again, it's subject to Pennsylvania inheritance tax, and you do get that stepped up basis. So whether it's real estate, stocks, an investment account, those type of assets that you transfer into the trust, you will get that stepped up basis. So I know that that's going to be a question that's going to be important to financial advisors, and so I wanted to make sure to cover that. Okay, so what is an asset protection plan? It's going to be shielding fellow business owners from potential personal creditors. So again, that would be nursing homes, divorce, disability, death. It's going to be protecting future beneficiaries from creditors, so divorce, death, disability. And it's going to be placing control in the hands of the client to shape the financial outcome of future generations. So again, our whole goal is providing that mindful legal direction for you and your future generations. And we're able to do that using these irrevocable trusts that still allow our client, in my example, my mom and dad, so much control. And so I want to keep repeating that because I think there's often a misconception about irrevocable trusts. And so again, these irrevocable trusts would allow my parents to still be in control. So the benefits of an asset protection plan, number one, it's not about hiding assets. So this is not impoverishment planning in any way. The client is still the legal owner of these assets. And the way that they're the legal owner is that when you have a trust, there are 3 different positions of the trust generally. So generally you have the settlor or the grantor, the person who sets up the trust. So in this case, it would be my mom and dad. Or if we go back to the analogy of the trust as a closet, it would be my parents who build the closet. And then they're also the ones who put assets into the closet or fund the trust. Okay, so they're the grantors, the settlors, sometimes they say trustors. Those are the people who create the trust and transfer assets into it. Then we have the trustee. That's the person who typically manages the trust assets and makes distributions of the trust assets to the beneficiaries. That's typically the job of the trustee. The third position is beneficiaries. So that would be who has the right to receive distributions out of the trust. So again, we have the grantor, settlor, the person who sets up the trust. Then we have the trustee, the person who manages those assets, who's the legal owner of those assets. And then we have the beneficiaries, and that's who ultimately receives those trust assets. So the reason why it's not about hiding assets is because in the case of my parents, if they create this trust and transfer assets into it, create the closet, put clothes or assets into it, it's still considered their asset for all across all intents and purposes. It's their asset. So we aren't hiding assets and we aren't taking away assets from them. That's not what this is about. An asset protection plan is a plan that uses existing law. So again, we're allowed to do this. This is using existing law to create barriers that prevent creditors from attaching to personal assets. The other thing I like to say here is that it really is giving you flexibility, because in the example of my parents, it is, if my dad goes into a nursing home, we're making sure that my mom would not be financially compromised, that she'd be able to keep the assets inside the trust in addition to her $128,000. So again, we're not hiding the assets, and we're also not saying that those assets can't be used for care. So if my mom makes the decision that she wants to pull assets out of there to pay for my dad's care, to privately pay, she can do that. The difference is that a nursing home isn't going to force her to liquidate or sell assets to pay for his care. So it puts the control back in the client's hands to figure out what assets do they want to liquidate, what do they want to pay to the nursing home, in what order. And that's really important, especially when we're dealing with real estate or family farms, because again, you may not want to have to do it all at once, or there may be certain property that other family members are using to farm. So this is really giving you flexibility. The other important thing to remember is that these irrevocable trusts, again, they're irrevocable, but the client, my parents, for example, mom and dad, are creating the trust. They have the ability to add or remove beneficiaries. They also have the ability to terminate the trust completely if they get the beneficiaries to sign off and agree to that. So that's the other thing to know, is that you can completely get rid of trusts if you would want to do that. In Pennsylvania, if you have an irrevocable trust and the person who sets up the trust and the beneficiaries all agree to terminate it, you can do that, and you can actually pay it back to the grantor, the person who originally set up the trust. So I always like to make sure that clients understand, as well as their trusted advisors, that just because this is an irrevocable trust, it doesn't mean there's not flexibility. And again, it also doesn't mean that you're hiding assets and that those assets can't ever be used to pay for care. They can. It just gives you the choice, timing, and how you're going to liquidate it. And again, you can always terminate the trust. The other thing is that I think we always think of, well, what if one client needs nursing home care? But what if it's a situation where my dad needs nursing home care and my mom needs assisted living level care? Having the trust would allow my parents to sell their house or liquidate assets and use the assets inside the trust to pay for mom's assisted living, which Medicaid does not cover. Where if my dad needs skilled level care, Medicaid would cover that. So if he's in a facility, Medicaid would cover his care, and the trust assets could be used to pay for my mom's care. So again, the trusts are just giving you the most flexibility. It's allowing you the ability to protect assets, and also it's creating a situation in which if one of you needs a different level of care, you're still being protected. So I wanted to make sure to talk about that here. So every person needs an asset protection plan. That could be because you have children who are underage. It could be because you don't like the in-laws and there are some divorce concerns. It could be that you want to protect your primary residence against a Medicaid recovery lien, because like I said, the primary residence is an exempt asset. But there are two things that can happen. Number one, if my dad's in a facility and my mom decides to sell the house, then those proceeds that were exempt when it was the primary residence are now available for his care because she liquidated it. And that's important, because in the example where my mom only needs assisted living level care, she would need those sale proceeds to pay for her care. So sometimes protecting that primary residence is really important. The other thing is that these trusts do protect against a Medicaid recovery lien. So when mom and dad both pass away, even though their primary residence was exempt during their life, if one of them was in a facility and receiving Medicaid, the nursing home, or I should actually say the Department of Human Services, can come back and put a lien on the house, which means that that claim against DHS would have to be satisfied before the sale proceeds could be divided. It also means that if you weren't planning to sell or the next generation wasn't planning to sell the real estate, that they might have to do that in order to satisfy that claim. You also might want an asset protection plan because you have a boat, an airplane, something really cool like that you want to protect. We protect a lot of rental properties and vacation properties, so additional real estate. So again, your primary residence is exempt, but any additional real estate that you own, that would not be exempt. So if you have rental properties or vacation rentals, putting them into a trust is really helpful because it protects those assets against long-term care. And then we have grandchildren. We're having more and more families decide that they want to leave assets to their grandkids. And so providing a way in which those grandkids can receive assets either at a certain age, certain life events like graduation, those things we want to make sure, and a trust can do that as well. So every person needs an asset protection plan. And on here, I wanted to talk about why in some cases would people opt not to do the insurance. So it could be, they have underinsured, could be they're excluded under a policy that they currently have, could be that the insurance company goes out of business, or it could be that the premiums, especially in traditional long-term care insurance, have increased. And so those are kind of the issues that we have with insurance products. It's not that they're not helpful, it's not that they're not good, but sometimes you could be underinsured. Sometimes what's happening could be excluded from the policy. The insurance company goes out of business or those premiums increase. And we've seen for traditional long-term care insurance, I've seen premiums increase, 20% or more in 1 year. And so it's just, again, it's how can we offer additional protection? So the key to an asset protection plan is time is of the essence. The reason why that is so important is because, again, in Pennsylvania, there is a 5-year look-back period. And so making sure that you're doing it in plenty of time, pre-planning is what we call it. Pre-planning is going to offer you some protection. The cost, it could be either a legal investment or it could be if you're using the financial products, it could be that you're purchasing a product. And when you're talking about legal professionals, I always encourage clients as well as advisors, you do want an attorney who specializes in elder law and in asset protection planning. And the reason is because, for example, as a doctor, if you have issues with your kidneys, you're going to go to a nephrologist and not a cardiologist. So I would say the most frequently asked question about this type of planning is, why aren't more people doing this? And it could be that they don't know that this planning technique is out there. Trusts are a very specialized area of law. So if you aren't familiar with taxation, asset protection, and trust and how they all kind of come together, then you may not be aware of this type of planning. You want to make sure that you have honest disclosure to a legal professional that you're dealing with. So making sure that you're upfront about what assets you have. And that's why the attorney, sometimes I'll be in with clients and I will be asking about their assets and they will say, well, why do you need to know this? The reason is because I have to know what assets you have, whether it be life insurance with a cash value or whether it be retirement or real estate. I need to know that in order to be able to make the recommendation. So if a legal professional is ever asking about asset information in this context with an asset protection plan, there is a reason that they are. And as best as you can, you want to disclose your assets. I would recommend periodic checkups. At our office, we recommend an annual review. We actually don't charge for that annual review. We do that just so that we can be touching base with the client, make sure that the plan is still going to apply, still going to accomplish their goals, that there aren't any tune-ups that we need to do. We also want to make sure that we're considering all alternative options. So, is a trust, do we need a business entity? Do we need a financial product? We want to make sure that we are looking at all different avenues. And again, that's why we really want the financial advisor and the accountant to be part of that discussion so that we can ensure that we're looking at all the different areas that we possibly can. And we want to make sure we're including the family to the extent you want them to be included. We want to have that conversation with them. That's really important because when we're doing these type of trusts, as I'm going to explain, a lot of times there are family members or family friends that are involved, and having them as part of the discussion can really help have everybody understand. The more questions, the more everyone understands it. And a lot of times people are going to be looking at different perspectives or different points of view. And so having them all come together is really helpful. So assets that you might want to protect: your home. And again, that's against the Medicaid recovery lien. Rental real estate, non-rental real estate, so vacation homes, IRAs, life insurance, bank accounts, business interests, collectibles, and future inheritance. Now, I do want to point out the IRAs. So the type of trust that we're talking about here, these irrevocable trusts, we do not recommend that you transfer IRAs into these trusts. And that's because IRAs have had deferred income tax. And by transferring them into these trusts, it's going to trigger all the deferred taxation. But what I will tell you is when we have people that have retirements, it can be really helpful if they have retirement accounts, because we know that in my parents' case, dad's retirement is available for his care, but my mom's is not available for her care. Furthermore, IRAs and retirement accounts can help us make it through the 5-year look-back period. We know we can't transfer them to the trust. So if someone needs care, if there's money in an IRA account, then we know we can use that to pay through the 5-year period and protect other assets. Okay, so I wanted to make sure to bring that up. The other thing is life insurance cash value. If you have a term policy, then you don't have to worry about nursing homes being able to tap into that. But if you have a life insurance policy that has a cash value, that is an available resource for nursing homes. And that's really important to know, because life insurance is the only asset that will pass to your beneficiaries tax-free, inheritance tax-free. Everything else is going to be subject to Pennsylvania inheritance tax. So making sure to protect the full amount of the life insurance can be really helpful to make sure that it minimizes your taxes. So life insurance, this is, again, we talked about cash value is available for nursing homes. Retirement, the retirement is available only for the owner's long-term care. So, and that changes state to state. So for example, in Pennsylvania, that is true. And I was talking to an attorney, a colleague of mine that practices in Maryland. That is not the case in Maryland. So that's really important because we live so close to the border. So in this case, they're actually considering wife. She has some dementia and Alzheimer's, so they're considering admitting her into a Pennsylvania facility because husband has so much of his assets in retirement accounts. And so if she goes into a Pennsylvania facility, she's governed by Pennsylvania law, and in Pennsylvania, his husband's retirement is not available for wife's care. So knowing what it is across the state lines is also very important. Annuities are going to be an available resource for nursing home care. So how do you create your own plan? So trusts are going to be part of an asset protection plan. I really love trusts. I feel like these type of trusts offer a lot of flexibility for clients, and it's really going to be a great tool for your clients to use. And again, it preserves the asset so that not all of your accounts are being wiped out by nursing home costs. So when is the time to use an irrevocable trust? So there are a couple of different ways you can use them. They can be during life, they can be upon death, and it depends what assets you're protecting and what you want the protection for. So for example, in the example of my mom and dad, let's say that they want to protect assets against nursing home costs. That means we want to create the irrevocable trust while they're living and transfer assets into the trust. Okay, so while they're living, we want to do that. Then there's going to be, under the trust document, there's going to be a set of rules that apply while my parents are living. How can we distribute assets? How do they get in and out of the trust? And then when the second of them dies, it's a new set of rules. And so again, mom and dad can decide that they want all of the assets to pay outright to us when the second spouse dies, or they may decide they want it to stay in trust to protect us against divorce or any of our creditors. So again, it depends who you're trying to protect, but you can do it either way, and you can do a plan that does both, that offers you protection during life or offers the client protection during life, and then upon death, it can continue to protect for that next generation. The time to use irrevocable trust is now, and the reason why is because there's a 5-year look-back period. And so the sooner you get that period started, the sooner you create the trust and transfer assets in it, the sooner the look-back period starts. The look-back period begins running the day you transfer those assets into the trust. So if you sign the trust document, set up the trust, that's not when the 5-year period starts. It starts when you actually transfer the asset into the trust. And also know that inside the trust, you may have multiple look back periods running. So if I transfer an investment account tomorrow, 18 months from now, I transfer additional money in, I have 2 different look back periods running. I have one for the initial transfer and one for the subsequent transfer. So sometimes we do have multiple trusts just so we don't have to worry about the different look back periods if we're funding different assets at different times. We also might use, so when we're coming up with our asset protection plan, we might use multiple irrevocable trusts. And the reason is because we do have a 5-year look back period. So if we have somebody who is in their late 70s or even in their early 70s and they have a house and some investment assets, maybe some rental properties, we're actually going to put each of them in a separate trust. Why do we do that? And the reason, let me explain. The reason we do that is because there's a 5-year look back period. So if they don't make it through, if they're in year 3 of their 5-year period and somebody needs care, we can actually terminate one of the trusts and use those assets to pay for through the remaining 2 years and leave the other 2 trusts intact. And then those 2 trusts will be protected. So sometimes we'll use multiple trusts for that reason. If we only use one trust, the problem is that if the client doesn't make it through the look back period and we have to undo the trust, then all of the assets that we transferred into the trust are going to be available again. So sometimes we will use multiple trusts so that we can make sure that we have options about making it through the 5-year look back period. This is a picture of Darth Vader. So I put that on there because, like I said, I have 3 sisters and they're all married. I'm not married, but they're all married and they have spouses. And so let's say that mom and dad didn't like one of their spouses. That would be like the Darth Vader of the family. How do we protect against that? I love leaving assets in trust for children. They can serve as their own trustee, and I can talk a little bit about with a client and with the advisor a little bit about what type of protection, what level of protection, but just know that they're always going to have more protection if you leave it to them in trust. And we can talk about how they can have certain flexibility, like they can serve as their own trustee, and then there's a certain level of protection they get, or we can have an independent trustee and they get more protection. You can also do a situation where right now, maybe they're in their 20s and it's okay that they're their own trustee, but you're thinking, well, what about when they start aging and get to the point where they're looking at long-term care? And what we can do is in the trust, we can allow them to appoint somebody at a certain time in the future. So you can do that as well. The benefits of the trust for you and their beneficiaries: it protects against divorce, it protects against debt, it protects against disability, and it protects against death. Because inside the trust, it creates almost like its own will. So when mom and dad, when Denny and Denise died, there's almost like a will embedded in there that says these are how the assets are distributed. The benefit is because those assets were already transferred into this trust while they're living, it does avoid probate. So not that we would do a trust solely to avoid probate, but one of the added benefits is it does avoid probate if we set it up and fund it during life. So the types of trusts. I get this question a lot. Do all trusts offer the protection? Because there's testamentary trusts. Those are trusts that are created under a last will and testament. There's a revocable living trust. Typically, that's a standalone trust, meaning my mom and dad would actually set it up while they're living, transfer assets into it. There's an irrevocable trust, where technically that is a living trust as well. If they set it up while they were still alive, it's still a living trust. It's just an irrevocable living trust, which I know sounds weird, but the word living just means when did you create it while you were living. So you can have an irrevocable trust that's technically a living trust. And then you can do a special needs trust. So let me explain a little bit about how these work. So I'm going to go back to the example of the closet because that helps me explain it better. So if my mom and dad are setting up a trust, so they're creating a closet and they're putting assets into it. Let's say they shut the door, lock it, and give the key to somebody else. That is an irrevocable trust. They themselves do not have the ability to unlock that door and pull assets out. A revocable trust would be one that they create or build the closet, put assets in it, shut the door, but they have the ability to open the door and pull assets out. Okay, so that's the difference between an irrevocable and a revocable trust. So a lot of times when you look up irrevocable, you're going to see all kinds of things that articles or whatever that people attach to an irrevocable trust and talk about what does it mean tax-wise, what does it mean for the grantor. But I think what's important, what I really want to stress here, I want to stress that an irrevocable trust just means that Denny and Denise cannot open that trust themselves, can't open the door and pull assets out of it. Okay, that's all it means for an irrevocable trust. When you set it up and you put assets into it, you yourselves, Denny and Denise themselves, cannot revoke the trust. Okay, but again, in Pennsylvania, all it requires is Denny and Denise and the beneficiaries of the trust to agree. Then you can. It just means that Denny and Denise themselves cannot. Okay, so let me explain the mechanics of how this works. So a revocable trust offers no protection. So if you have a client that has a revocable trust in place, just know they're going to get no asset protection using that trust. In order to get asset protection, it has to be an irrevocable trust that's established prior to the claim. Now, when you're doing nursing home protection, that just means prior to somebody needing long-term care. The reason we say established prior to the claim is because it protects against all creditors. We just think of a nursing home as being the biggest creditor. So if it's a car accident, if it's somebody on the property that sues, as long as the trust was established prior to the claim, you're going to get that asset protection. Okay. Now, let me go back here because I just want to explain a little bit about how the trusts work before I end. And then if you're listening to this and you actually want to see a visual and a hypothetical, I'm going to be taping them immediately after this, and I'll be sending them all together. So I would go to the hypothetical number 1 and the hypothetical number 2, and you can see how this plays out. But let me just give a brief description. I'm going to use my parents to explain this. So let's say Denny and Denise set up a trust, and they put their house, and let's say they put an investment account worth $200,000 into the trust. And the goal is that they want to protect against long-term care. Okay? So how the trust would work, they are the grantors. They're the settlers. So they're the ones who set up the trust. They build the closet. Okay? They fund it. They put the assets into the trust. What happens in these trusts in Pennsylvania is if my parents had the ability to set up a trust, fund it, and then had the ability to make distributions out of the trust, if they were the ones who actually had the ability to open the closet door and pull assets out, then it is available to their long-term care creditors. Available to any of their creditors. We just think of a nursing home as the biggest one. But if they set up the trust and they are the trustees, which means they manage the assets inside the trust. So if you think of the closet example, if they decide what comes in and out of the closet, they're buying and selling. If it's a house, they have the right to sell it. They can liquidate anything as the trustee. They still have that power and control. They also have the ability to decide who receives the trust assets when they die. And they also have the ability to decide who has the right to open the door. So they do not have that power. So what we do is we name them as the trustee. Denny and Denise would be the trustee of the trust. Typically, the trustee has the power of distribution. So what we do is we say, we're going to allow them to have all the powers a trustee normally has. But we're going to take the power of distribution and we're going to take that away from them. And what we're going to do is we're going to give it to somebody that we call the trust protector. Okay, so again, normally the trustee has the power of distribution. What we do is we create a position that in our office we call the trust protector. And really that's the person who can open the closet door and pull assets out of it. It's the person who can make distributions. Normally that's the trustee, but we take that power and we give it to somebody we call the trust protector. That could be the kids. So in my example of my parents, Denny and Denise set up the trust. They're the trustee. And then what they do is they say, if anything needs to come out of the trust, we're going to name our 4 daughters as the trust protectors. And so let's use the example of the house. So let's say mom and dad decide to sell it. They, as the trustee, have the power to sell it. And then the sale proceeds are payable to the trust. If they have a financial advisor or any other banking institution, they can go there, open up an account, deposit those sale proceeds into that account. Okay, and then they can invest it however they want. But remember, in our example of the closet, they can't open the door and withdraw this asset. So if they have named my sisters and I, the 4 of us, as the trust protectors, people have the power to make distributions out of the trust. We can actually open the closet door and pull assets out. Okay. Now, the trust document is going to say we have discretion to distribute that to the beneficiaries, and we would be the beneficiaries of the trust. Okay. So it allows us to pull assets out and distribute it. What that is it's a way for us to get assets out of that trust. What we do with those assets once we withdraw is completely up to us. And if we want to, we can always distribute it back to our parents. Okay, so that's the way that we're able to get assets out of the trust and get them to mom and dad. So in the example, let's say that they put their house in. So my parents, let's say they have a large house, let's say it's worth 400,000. Okay. They sell it and they downsize and they buy a $200,000 house. So if we've transferred it into the trust, they as the trustees decide to sell it. They as the trustees decide to purchase the smaller house, the $200,000 house. Then the remaining 200,000, what they decide to do is open up an investment account and put those deposit those funds there. Then let's say they decide they want to buy a brand new car. So they want to pull out $20,000 out of the trust. What they would do is they would come to my sisters and I and ask us to open the closet door and pull out the 20,000, to pull the 20,000 out of the trust. We would do that. And then we would make a distribution to ourselves. Okay. Now, if my parents come to us and we say, no, we're not going to pull out the 20,000, they do have the power under the trust to fire us. So they can say, nope, we don't want you to serve. So let's say I decide I'm going to be mean and I say no. They can actually remove me and my other three sisters can make the distribution out of the trust. Okay. It would actually be deposited into our bank account. So let's just say it's deposited in my sister Jess's account, the 20,000. It's not taxable to her because it's considered a gift. And then when she turns around, she can either pay it directly to the dealership to buy my parents a car, or she can gift it back to them. Okay. Now, the only tax implication that happens here is that when she gifts it back to my parents, or when she pays it to the dealership and it's a gift to my parents at that point, it does have to be below the federal gifting amount, which is $15,000. Jess is married, so that means she can split it with her husband. So she can actually give my mom $30,000 and my dad $30,000 every year out of the trust. She doesn't claim it as income, and nobody has to file a gift tax return for it. So it allows us to get assets out of the trust and back to mom and dad. Okay. Now remember, if I am saying, if I, as one of the 4 trust protectors, say no, I'm not going to agree to this, they can remove me. Additionally, if they decide that they want to change any of the beneficiaries, meaning that when the distribution comes out to my sister Jess, because I'm not agreeing to it, they can actually remove me as a beneficiary as well. So even though it's an irrevocable trust, they can change who has the power to open the closet door and who can receive assets out of the closet. And what that does is it allows my parents to still be in complete control of their assets, because again, they're the trustees, so they have legal ownership of those assets. So when it happens and when we make the distribution out, the signer on all of the accounts and the person who makes all the decisions is the trustee. So my sisters and I can't make a distribution out of that trust without my parents knowing, because they're the legal owners of the trust. So that's how we're able to offer that protection. So me as the child, I can't reach into the trust without mom and dad knowing it. They have the ability to add and remove me either as a trust protector, which is the person who makes distributions, or as the beneficiary. Okay. So again, this is a legal method by law that we're allowed to do. And there is a 5-year look back period. So what that means is that the assets have to be in the trust before they're fully protected from long-term care. But assuming that they are in the trust for those 5 years, if mom and dad ever need anything out of the trust, we can get it out because we're the trust protectors and we can make distribution out if we need to. We can also terminate the trust completely if all of the beneficiaries, which would be my sisters and I, if we all agree. Remember, mom and dad have the ability to add and remove beneficiaries too. So if I say, no, I'm not going to agree to the termination, they can just remove me as a beneficiary and have my 3 sisters sign off and we can terminate the trust. So I'm going through all of this because I really am passionate. I'm excited about this. I think it's a great planning technique. I practiced for about 7.5 years in Williamsport, Pennsylvania, and this is the type of law. We had 3 law firms up there that this is all that they did. This is the area that they specialized in. And it's called asset protection and elder law. And when I moved down here, this isn't a strategy that a lot of people are using, but it's something that we should be using. If anybody has additional questions, I am a co-author of a book called What You Really Need to Know About the Second Half of Life, Planning for the Second Half of Life, that talks about all of these strategies. Additionally, I am one of the co-authors of the Pennsylvania Trust Guide, which is published by Beisel Publishing Company. What it is it is almost like a textbook that talks about all types of trusts, how you use them in planning, answers questions, and it's really as a reference guide, and it's a reference guide for other attorneys in Pennsylvania, as well as any tax professionals in Pennsylvania. So, and we talk about this type of planning or these type of trusts in that book. So again, I know that it's not something that we do or have seen a lot in this area, but it is a great planning technique, and I'm very excited about it. And I welcome any questions or concerns that you have about it. You're welcome to call me at 717-655-2676. That's 717-655-2676. And again, we're located at 20 East 6th Street, Suite 206 in Waynesboro. And what we're trying to do is we're trying to do virtual seminars once a month. And then I'm doing things like this, like taping little sessions to be able to get out to advisors and accountants so that they know that this type of planning does exist. I'm also happy to meet with any clients that you have. We do offer a free initial consultation, so I usually block an hour and a half to 2 hours of my schedule, and I'm happy to meet either at your office, my office, virtually, or over the phone to talk with you and your client about this type of planning. Again, like I said, I'm really excited about that. And as I'm looking at it, I see that suite, there's no E, like I mean suite, not suit. There should be an E on the end of that as I'm looking at that. I apologize. So we're in suite 206. So I'm happy to talk, to meet. Again, I'm really excited about this type of planning. I am, right after I end this session, I am going to do 2 hypotheticals to show the different ways in which you can use these type of trusts to offer asset protection. So I would encourage you to go check them out as well. And thank you so much for listening. I know that it's been almost an hour, but I really do appreciate it. And again, you can reach me at 717-655-2676.